15, and I'm going to read it verbatim for you. The amount of bail to be required in any case is to be regulated by the court in the exercise of the discretion by the Constitution and these following rules. The bail shall be sufficiently high to give reasonable assurance that the undertaking will be complied with. Basically, that she's going to show up in court when she's supposed to show up. The power to require bail is not to be so used as to make it an instrument of oppression. Yes. Right? That concerns me with these high bails. The nature of the offense and the circumstances under which it was committed are to be considered. That's what I'm doing. This is a case that we're dealing with a hindering of this child. The next thing is the ability to make bail is to be regarded, and proof may be taken upon this point, which I think I've gotten. The future safety of a victim of the alleged offense in the community shall be considered. All right, and that's why I asked some of the questions I did about her contacts with the community, etc. But one of the things I am concerned about is that, you know, you can't set a bail just to keep somebody in jail. I mean, that's not what this Constitution or laws of this country is about.
I apologize, Ryan. I'm not trying to. When I said get her attention.
But I mean, $1 million when you see that the woman doesn't have that, that would be to keep her in jail, don't you think?
If she really doesn't have it, perhaps.
And we're talking about a third-degree felony here. We're not talking about a capital murder. We're not talking about a murder. We're not talking about aggravated sexual assault. We are talking about a case that the punishment range is 2 to 10 years, not 2 to 20, not 5 to 99, not life. So let's look at it for what it is. I mean, I understand everybody's concerned. I understand that there possibly is outrage in the community and things of this nature. But as a judge, I got to look at the law. I got to make my decisions based upon the law and that alone. So that was the whole purpose of this hearing. And I'll be very frank with you, I just don't believe everything that I've heard today, that it should be $1 million.
I understand that, Your Honor, and obviously, you know, we expect you to abide by the law. We know you're going to do that, but the law gives you quite a bit of leeway. And you are entitled to consider not only the level of the offense, but also any extenuating factors. And I think the fact that you are allowed to consider any aggravating factors. In fact, there's case law to back that up. And I've outlined what those aggravating factors are. This is not a standard third-degree felony. If it was, then $15,000 might make sense. But this is not a standard third-degree felony. This is a person that it took great efforts just to get back into the jurisdiction, to find in the first place and to get back into the jurisdiction. And we're merely asking for a bond that will ensure her attendance in court to answer for these charges.
Very well. Thank you, Mr.
And Your Honor, one more thing. In the event that the court, I'm assuming that the court will set a bond, whether it's changed or not, but we would ask as conditions of bond that the cost of extradition of $3,177.97 be ordered to be paid as a condition of bond, that she also be ordered to surrender not only her passport. I realize there's some confusion about where that is, but we would also ask that she be ordered to surrender her driver's license, because you can, under some circumstances, use just a driver's license to get into Mexico. Maybe not to get back into the United States, but to get into Mexico. And she's already shown a willingness to go there.
In my understanding, she doesn't even have that.
She doesn't, Your Honor.
She doesn't have anything. Okay. Real good. Thank you, Mr. Rousseau.
Thank you, Your Honor.
All right. The court has heard testimony concerning this bond reduction hearing. And after hearing testimony, the court's decision is this. I am going to lower a bond for Ms. Couch to $75,000. I think that's an amount that is appropriate for this type of case, and the fact that I don't think it is oppressive. I think Ms. Couch can make that. if in fact she does make this bond, I'm going to have several conditions that I want, and I talked to Ms. Couch about this at the arraignment. I want her to report to the Community Supervision and Corrections Department of Tarrant County, Texas, immediately after she makes bond, and to continue to report as scheduled weekly. I want her weekly reporting. I want her to stay with her son at his Tarrant County address, and I want to have a good address and phone number for that home. I didn't ask for the address because I wanted to remain secretive for you, for everybody. I want her to abstain from the illegal use of controlled substances. There's been no allegation that she takes drugs, but I want to make sure that she doesn't, and she will be tested on that. So I want you to explain that to Ms. Couch. I don't want her to purchase, possess, or transport any firearms or weapons at all. My understanding that there was a weapon found in Mexico. I don't know whose weapon it was. There was no discussion or no testimony on it, but I don't want her with any weapons. She has to pay a $60 a month supervision fee while she's on bond to the Community Supervision and Corrections Department. She must fully participate in and comply with the rules and requirements of our probation department. Electronic monitoring program. I do want her on an electronic monitor, and I told you folks that I wanted that. If and she isn't to change her dress without prior knowledge to my probation department. So I want her at her son's home, and that's where I want her to stay. If there's anything that changes, I want to be made known of that. I don't want you to consume any alcoholic beverages, Ms. Couch. You're not to refuse a breath, blood, urine, or field sobriety test if requested by the court or my probation department. You are to submit and pay for non-dilute urine samples for testing for controlled substances, cannabinoids, as directed by my probation department. You are to avoid persons and places of harmful or disruptible character, meaning I don't want you around clubs and things of this nature. You're going to be kept really, really strict on the lock and key. And you are going to be released to my probation department once a bond is set on that. You are also to allow the probation department to visit you at home or elsewhere at any time. And we want to make sure that you follow all these rules and regulations that I'm going to sign into effect.
Your Honor, may I inquire, you said you want her to stay in that home. Are you ordering 24-hour home confinement?
At this time I am. And that's subject to be reviewed after I look at it for a while. All right? Now,
Your Honor, and
yes.
she gets time off the monitor to visit lawyers and doctors, is that correct?
Yes, she can do that. I also am going to order that she pays this Sheriff Department restitution of $31,7793 for going out there to pick her up and getting her back here. All right? That takes care of the bond reduction hearing. There's one other matter I want to put on the record.
All right, guys, it looks like the
And
bond
that
hearing
is-
is over. So we're going to cut out of this and go to Governor Ducey's State of the State in just a minute.
I'm going to enter into the record, and I've given copies of this order to the lawyers involved in this case, both the state as well as the defense. And this is an order regarding discovery and media dissemination. I have previously instructed counsel for the state and the defense that the Michael Morton Act shall apply to these proceedings for all matters involving discovery pursuant to Article 3914 of the Code of Criminal Procedure, and the parties are to make no extrajudicial statements or otherwise engage in conduct calculated to, in effect, try these proceedings in the media in violation of Rule 3.07 of the Texas Disciplinary Rules of Professional Conduct. The court believes it is best to memorize the same in writing, which I am doing. The parties, both sides, have agreed to the entry of this order, and accordingly is therefore ordered that the Michael Morton Act shall apply to these proceedings, and order that counsel for either party in this cause shall not make any extrajudicial statements that they expect to be disseminated by means of public communication. And I'm talking about, faxes, emails, Facebook, Twitter, and whatever else that we have. And I'm a little at a loss because I don't join any of that stuff. I don't know any of that. But I know that it's out here today. So I want you to stay away from that. And I find it amazing that people use that. I have defendants that come in here and that's how they're caught, because they're on those things, all right? Okay, anything else? Right? Public communications, the lawyer knows or reasonably should know that it will have a substantial likelihood of materiality prejudice in these proceedings. Except as provided by Rule 3.07C of the Texas Disciplinary Rules of Professional Conduct, it is hereby further ordered that the lawyer shall not counsel or assist another person to make these statements. This order also applies equally to dissemination of any discovery exchanged by the parties which has not been formally admitted into evidence in these proceedings. That's going to be signed by me when